Next case set for argument this morning is case number 29038, Jessica Benedetti versus Stephen Benedetti. Counsel's here. Yes, both counsel are here. Good to see you both again. Rhonda, you've got an injury, it looks like.
Running San Francisco half.
I mean, if you'd rather just sit.
I should be okay. I think I'll be okay.
All right, so each party is represented by counsel. Each will have 15 minutes to present your arguments. Of course, the appellant may reserve up to 5 minutes for rebuttal. And you can keep track of that on the television. I'll try to also let you know as you approach whatever time you decide to leave for rebuttal. We've read the briefs and are ready to proceed. So, would you like to reserve some time?
I waive, Your Honors, 5 minutes.
5 minutes. All right, you may proceed. Thank you.
Good morning, Your Honors. Mr. David, Attorney David. This case, Judge, is a legal question, I believe. Actually, two issues, how the court erred, and it involves a lengthy divorce that was a contested divorce with some bad behavior on both sides. Results in a 2-day trial, approximately September 8th and September 11th. Testimony was taken at the trial. What happened subsequently after the trial is really what's issue here, whether the court ordered the parties to attend via their attorneys in chambers, issues were discussed, and without any hearing, court on its own issued an order which suspended Mr. Benedetti's parental rights. So never was a hearing, never was there any testimony ever taken or evidence taken, or nor did he ever waive that hearing. That suspended his parental rights and ordered him to see psychologist Dr. Tanner, and until further order of the court, then his parental rights would be reinstated. So next day, he did not comply with that order, and court was immediately taken into custody for 8 days, and then a custody hearing, so it was a little bit backwards. Contempt hearing was held, found him guilty. At that time at the contempt hearing is when they actually explained to him what the orders of the court were, and then he was found to be in contempt of those orders. So he was never actually on the issue of whether his parental rights should be suspended or should he have a psychological evaluation. He was never given that opportunity to be heard or present evidence or even present his own.
And that would have been at what, October 14th?
October 14th, correct.
You're saying he didn't receive notice, or?
He didn't have a hearing. His attorney was present. He did not have a hearing, nor did he waive. I believe later on, Judge Dezo, in her motion to the letter to the Supreme Court, even had said that he was correct. No testimony was ever taken, and she thought testimony by affidavit was sufficient. Mr. Benedetti challenged that and still was never given any opportunity to present witnesses or testify or challenge that whatsoever. So later on, this order was incorporated into the divorce decree. Therefore, our position is that this is voidable, given that he was never given that due process, the right to a hearing. The second argument, that what was actually incorporated into the divorce decree later on is voidable, I guess you would say, for two reasons. First of all, it's not the child support portion of it is not complete. It doesn't tell it just leaves it open and doesn't really address, the spousal support. It doesn't address spousal support. It just leaves it open for the court in the event he becomes employed. It can be addressed. Doesn't reduce it down to zero or any amount.
Is that different from the court addressing it and saying we will establish it if appropriate at a future date? In other words, if it was addressed but not established.
My interpretation is that it has to be more specific. It should be reduced down to zero. It should be specific. And the order itself is vague. This is a 46-page divorce decree, which is insanely lengthy. In the court's own conclusions of law, it gives Mr. Benedetti parental rights. But then in the next paragraph, it also suspends those parental rights. It doesn't really tell him what he's supposed to do. Specifically, on page 34, I believe, it does say he shall engage in counseling to work on his emotions at the appropriate level dealing with plaintiff. but based on the events that occurred after the trial, parenting time is suspended until he completes a psychological assessment with Dr. Robin Tenner as required by the order of October 14th. Once the assessment is complete, he may file a motion to reinstate parenting time order contemplated above if appropriate.
Have you been ordered to do a psychological evaluation during the temporary orders?
That was the October 14th order.
Was there, in the temporary orders prior to that, was there an order going to
No,
do any counseling or anything?
I don't believe so. There might have been counseling, but not a psychological order. So subsequently, Mr. Benedetti, the reason it's vague, he complied with this. He contacted Dr. Tenner's office due to a conflict in scheduling. She was not able to see him, and she notified the court of that. He was held in contempt and found to be in contempt, but not willfully in contempt, because he didn't follow the court's order of meeting with Dr. Tenner. He went to his own doctor, who I believe was Dr. Bobowich, and that wasn't enough for the court. Then they said, no, that was not sufficient. We wanted to be from Summit Psychological, and it had to be Dr. Orlando or somebody else specific from that agency. He did follow through with that, and it was not a positive finding for him, so he had a second opinion, and the court would not consider that, and that was from the chief psychologist from the Cleveland Clinic, I believe, and the court wouldn't even consider that or allow him to have a second opinion or even address his parenting time at all. So he's been trying to comply with that vague order, and no matter what he does, the court won't review it or give him the opportunity to be heard. It's been about 3 years since this divorce decree was issued. He's not been able to see his children since then. His attorneys had, I believe, left at the time of the contempt hearing, and so he had filed several motions on his own, and that led him to the label of the vexatious litigator. So he's had difficulty getting to the court and complying with the court order because he doesn't know exactly what he needs to do to be able to see his children. And all this could have been solved back on October 14th if the court had had a hearing and taken evidence and to lay out those conditions, what he needed to do, why he needed to see Dr. Tenner, and then what after he met with Dr. Tenner, was he required to follow through? The divorce decree is silent on that. It just says he needs to meet with Dr. Tenner, which he attempted to do. Later on, Judge Deza retired, Judge Giletto steps in, and he adds his own conditions later on, which are not part of the original divorce decree. He's now saying that it has to be a psychiatrist. But again, no hearing was ever held to determine these conditions. So to this day, Mr. Benedetti still has no idea what he needs to do to be able to see his children. He's attempted to see about three to four different psychiatrists, and none of them, he's had no success whatsoever with the court.
What about Attorney DeHaven's argument that, I guess that your client may have forfeited the right to challenge the decree by not appealing it?
He did appeal, and it came back because it was not a sufficient order, it was not a final appealable order. So it did come back, and then somewhere a 60B motion was filed on this exact issue that no testimony was ever taken, or he was not given the opportunity to be heard. So I believe he did file the appeal, and then because it was, I don't think he filed a second appeal in January, but he actually did, and then because it wasn't final appeal, it took a while for Judge Giletto to have a hearing to decide if it was a final appealable order, and that's when he added the last line as to the spousal support. So I think it was always Mr. Benedetti's position that that's still not a final appealable order. Thank you.
That's it.
Is it, thank you.
Okay, you'll have your full 5 minutes.
Okay, thank you.
All right, Attorney DeHaven, you'll have about 15 minutes.
Okay, thank you, Your Honors. Ladies, excuse me, may it please the court. My name is Darren DeHaven. I am here on behalf of the appellee, in this case, Jessica Benedetti. Attorney Connick is right, this has been a very long case. This one was initiated back in 2013 as a contested divorce with custody. It has, I think, every making of a crazy law school case It's gone so many different directions, and we're here today, though, on essentially those two issues. First question, which is the issue of whether or not this is a final appealable order. And there was the divorce decree came out on April 14th of 2016, and this case was appealed. That is correct. The appellate court didn't say, we don't have jurisdiction, it's not a final appealable order. They handed out your order that said, show us that it is. It was voluntarily dismissed by Mr. Benedetti. His counsel at the time filed a motion for a non-protunc, asking about the issue of spousal support, and on January 20th of 2017, that order came out. That order does address spousal support. It doesn't say, and there's no requirement in any of the cases that I found, and certainly not in the rules, that says you have to say a specific, hard, rigid statement that says no support is ordered. What it does say, if you look at Civil Rule 75F, it requires that the order determine the appropriateness of an award of spousal support. To find out what that word means, we looked at Ohio Revised Code 3105.18c, which says, in determining whether spousal support is appropriate and reasonable, and it lists out all the factors. This court, in their judgment entry, the non-protunc on January 20th of 2017, said, based on the above and the statutory factors which this court shall consider regarding spousal support. Now, it doesn't grant spousal support. The court didn't grant spousal support at that time. It just deferred it to a later time. And the key word in there is, if any. That may never materialize. It's up to the plaintiff, or the appellee in this case, whether or not she wants to do that. So by the court saying that it addressed the appropriateness and not awarding spousal support, it denied spousal support at that time. It did set up an avenue for it to come back later, if necessary.
But isn't the usual procedure, and maybe one case law provides that you do enter a $0 amount subject to continued jurisdiction in court?
That may be the usual procedure, but I don't think that's one of the, or part of the statutory or requirements under the rules. Just that it's, the appropriateness has been addressed, and in this case it was. All right, now going on to the question, the second question. Mr. Benedetti has not paid spousal or child support in years. He's always looking for a reason to try to invalidate any order that establishes the obligation for him to pay child support. He's trying to attack the divorce decree, saying it was a void judgment because of what occurred back on the 14th. And I'd like to give the court just a little bit of background on what happened on the 14th. Mr. Benedetti's behavior, and this is referenced in the transcript that was filed for the hearing, the contempt hearing that occurred on October 22nd. Prior to the 14th, Mr. Benedetti would refuse to return the children. No matter what happened, he wouldn't get them, or he wouldn't give them back. He wouldn't acknowledge the court's authority to send them back. The court had that hearing. The judge was out of the country and came back on the 14th. Set that hearing, called counsel in on an emergency basis or on a quick basis, and this was discussed. And she said, "I want those children returned." Mr. Benedetti was not in the courtroom. He was down the hallway near the near the bailiff in one of the attorney rooms. His attorney walked the order down or talked to him about that, and his response in front of the bailiff was very inappropriate. He essentially, and I'm going to paraphrase, refused to acknowledge the authority of the court or the order that that court was issuing to return those children. Next day there was a contempt hearing scheduled. That was the 15th. Motions were filed. The court ordered that he be held pending his hearing. And the reason the court did that was because they could locate the children and return them to mom. And actually at that point in time it was just it was just the son, because the daughter had been taken from school by mom to return him to her. So to get son back, that's what had happened. Strongsville Police went up and assisted in the returning of those children.
So was the October 14th event scheduled as a hearing, or was it
The order said a notice of hearing, but it was just, like how Summit County Domestic Relations Court handles a lot of their temporary hearing, or temporary orders. Parties go in, they listen to attorneys, or sometimes as the attorneys go in, they listen to the attorneys, and then the court issues temporary orders. And that's a point in this case, is the court has the authority to issue temporary orders. There's the court conducted its trial, and it concluded in September of 2015. The order, the divorce decree didn't come out until April. Reason being is Mr. Benedetti filed a motion to disqualify the judge in the Supreme Court, and that sort of closed everything down for a while.
So was this a temporary order hearing?
I believe that the result of it was for temporary orders. I do believe that, Your Honor. The court does have the authority between the time of the hearing, the time of the trial, and the time of issuing the divorce decree to issue rules and orders that affect the safety of the children, that affect how the parties behave with each other.
Ex parte.
I guess in theory they could do it ex parte. In this case, it was not ex parte. Ex parte is defined as, notice or lack of notice, lack of representation, without one party present. Mr. Benedetti received notice of the hearing on the 14th. Mr. Benedetti had counsel present at the hearing, at the hearing on the 14th. If we look forward 8 days after that, Mr. Benedetti was released from Summit County Jail for the hearing on the contempt issue about why he disregarded the court's order to return the children. In that hearing, he was present, he was permitted to examine witnesses, which he did, he was permitted to present testimony. And the court went in depth with him at that time about her order that he receive psychological counseling. And one of the concerns that she expressed was that she had to comfort herself in the fact that he wasn't just going to disappear with those children. Evidence in front of the court at that time, especially for the contempt, he refused to return them. And the court was justified in that. But he did have his opportunity on the 22nd to discuss in court, present evidence on that issue of the psychological counseling.
So the same issues were addressed on the 22nd that were the subject of the October 14th?
There was testimony presented essentially on the contempt, on why he wouldn't return the children, but there is extensive dialogue in there. All the issues are intertwined. There is extensive dialogue in that transcript, and the judge addresses exactly why she put that order in place, has dialogue back and forth with Mr. Benedetti at that time. And his response was, Your Honor, I'm going to make that appointment right away. So he clearly addressed it on the record in open court for his hearing. One thing I think in my time, I've got one more. Okay. One thing that I think is important for the court to understand too is Mr. Benedetti at one point in this case started trying to say the trial court is without jurisdiction. Anything that the court does is void after October 15th. So he will not acknowledge the divorce decree, despite the fact that within a few days of the divorce decree coming out, he got remarried. But at one point in time, he just started everything he filed and everything he said, this court has no jurisdiction. Prior to that, if we look at his conduct from the time of the divorce decree up until the time he started saying no jurisdiction, Mr. Benedetti surely was trying to avail himself of that divorce decree and what it called for. I spent some time yesterday going through the docket, and this is all part of the docket. Mr. Benedetti, from April 14th of 2016, filed 13 separate motions trying to enforce the divorce decree with the court, most of them for motions to show cause, some emergency ex parte motions. He was doing this even after the judgment entry non-proton came out on January 20th. After that, on February 5th, he filed an emergency ex parte motion talking about marital assets awarded under the divorce decree. 2 days after the appeal deadline, he filed a motion to show cause under the divorce decree. March 24th, motion to show cause under the divorce decree. May 9th, motion to show cause under the divorce decree. June 27th, motion to show cause under the divorce decree. And then starting July 23rd of 2017, that's when he starts saying the court has no authority whatsoever to hear him based on something that occurred almost 2 years prior to that. It is worth noting too that he filed this appeal May 15th of 2018. 1 month later, he files a small claims action in Barberton Municipal Court trying to enforce the marital property division of this decree, the same one that he's challenging in this court, saying that it's not valid because the court had no jurisdiction.
Is that part of the record?
No, Your Honor, that is not.
Well, can't consider that.
Okay.
Is there something in the record that tells Mr. Benedetti what it is he needs to do to be able to see his children prior to October 14th?
He had visitation at that point in time, but it was because of his erratic behavior and his refusal to return the children to the court.
Was there a requirement for him to seek counseling or to have a psych eval done before October 14th, or did those come up after October 14th?
I can't recall right away if there was one before October 14th.
There certainly was one at that.
There was one at that time, yeah, that was a condition for him to be able to resume seeing his children.
And Attorney Kotnick said that to this day, he doesn't know what he needs to do. Is it your contention that he does know?
Oh, he absolutely knows, Your Honor.
And what order would, and where would he find that?
If we look at, well, first off, the October 14th order establishes that. In the 22nd hearing of October, it talks about, again, what the need is to go see Dr. Tenner, have her do an evaluation once the court gets it. And also, the other thing, and kind of throws the branch in the spokes here that stopped everything, she also says in that order that opposing counsel will get to see a copy of that order. Well, that's been the sticking point.
The psych eval, you mean?
The psych eval, I'm sorry, yes. That's been the sticking point going forward. He refuses to show that over to anybody. And everything always has to be on his terms. You know, it made it sound like Dr. Tenner wasn't available to see him. That's not true. Mr. Benedetti called continuously her staff to the point where she said, I can't see him. He got his own Dr. Bobowitz, and when we received the factual summary part of that, it contained a lot of errors, a lot of factual inaccuracies. There's always been a need to see what he's telling somebody in order that we can do our job and cross-examine as need be to make sure that the truth comes out. He refuses to show that report. So he did go to Metro and did get where his wife works. His wife's, I believe, a physical therapist there. Did receive an evaluation, but again, that's never been made present for any of us to see, to discuss. He's well aware, he needs a psych eval, he's got to come into court, we've got to be able to talk about it, make sure that the right things have been discussed, and that they base their determination on factual scenarios. He did receive the psych eval, as Attorney Kotnick said, from Summon Psychological, and it did impose various items on him on what he needed to do. The court heard that. The court said, yes, this is what you need to do. And then he went off and he got that other evaluation. But again, he's always been his own worst enemy here. He will not share that evaluation to make sure that everybody's alleviated of the fact that he's not going to just take off with these kids again. If there aren't any other questions, I believe I'm done.
I just want to be clear, when you say you won't share that evaluation, you're talking about the one he independently got?
Correct. The two that he independently
The two
got.
that-
First one from Dr. Bobowitz, and then the second one from the name escapes me, the gentleman from Metro Health.
Okay, so neither of those.
What about
Correct.
the Summit Psychological one?
Haven't seen that one. I saw the judge asked him to do a small little thing on the very end, I think the last couple of paragraphs of it, and we did see that. That is under seal though, but we did see that.
Okay, thank you for your argument.
Thank you, Your Honor.
And you'll have 5 minutes for rebuttal.
Thank you, Your Honor. Judges, we're not here because of Mr. Benedetti's behavior, or either of the parties' behavior during the divorce proceeding, because it was atrocious on both ends. Specifically, Judge Dezo relied on, she states in her own letter to the Ohio Supreme Court,
Is that part of the record?
that's part of the record, Judge.
Or is it part of what was submitted here, or is it part of the trial court record?
It was, no, it was,
Yes or no?
no.
Okay.
Again, we can only consider.
Well, it was
the
attached
record.
as a journal
But
entry.
that wasn't an entry that was presented to the trial court as evidence in this case.
I believe it was. I'm not sure. I'm not sure.
Okay, well.
Okay, I'm not sure. Rule 75 is what Judge Dezo relies on, and when she imposes this temporary order on October 14th. And even the Rule 75 at some point says the court shall grant the party so requesting an oral hearing within 28 days to modify that temporary order. Mr. Benedetti was taken into custody the next day. He didn't have an attorney anymore, and it's debatable on that record of whether he was appointed an attorney. But anyways, he had no time to prepare. He had no knowledge of any even upcoming hearing. He was taken into custody by the sheriff before the hearing, before a contempt hearing, at which time he was found in contempt. Judge Dezzo, in that hearing, the transcripts which were provided, explains to him why he's in contempt, not giving him an opportunity to present his own evidence. He was in jail for 8 days. He had no opportunity to call anybody as witnesses. He had no attorney at that point. His attorneys, I believe, at that point had withdrew. Mr. Benedetti wants to do anything to see his children. We believe he filed a notice of compliance through his attorney with the court that he had these evaluations done. I don't know who had access to it or who had read it, because it didn't sound like at that time when he was not able to see Dr. Tenner, had used his own doctor through the Cleveland Clinic. He was denied that opportunity because they said that he didn't follow the court's order of seeing Dr. Tenner, therefore you're in contempt. He had no opportunity to even rebut anything, so he did comply with the next doctor, who was Abradovich. I don't know if that was made available or not, but I believe it was referenced in the divorce decree, some of the findings. Again, he's not given that opportunity to even have a second opinion. Later on, Judge Giletto says, no, we have to have a psychiatric report based on what Dr. Abradovich found. In fact, his later doctor states Dr. Abradovich is wrong. She's not a doctor who is able to even prescribe medication. So she basically, a second opinion just says she's completely wrong, but he's not able to present any evidence. It's her opinion or nothing, and he's not given that opportunity at all. So he's still unaware of what he needs to do to see his children. He's tried so many different avenues, and at this point he's basically just given up because he can't file anything, and no matter what he does is just wrong. There is a journal entry as well, that the hearing was held on October 22nd, where he was found to be in contempt of that order. Is still our position that that was not an evidentiary hearing, that was a contempt hearing. Did he comply, where Judge Dezzo explains to him what her temporary order is and whether he complied with those conditions or not. He never had the opportunity to present any of his own witnesses, and more importantly, he never waived a hearing. There's no
Was he
evidence.
represented by counsel?
He was not at that point. His attorney, I believe, was Coors and Valenti, and they had withdrew right when he was arrested. So at that point, he had no attorney, and I don't know if he requested one or not, but he had no attorney, and he didn't know of an upcoming court date, so he had no opportunity to prepare or be heard or present evidence.
You're good? All right, thank you both for the arguments this morning. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail you each copy of the decision on the day it's released. You can also check the